Hello, everybody. Welcome. My name is Paul Golin. I am Executive Director of the Society for Humanistic Judaism. For those of you who are new and maybe joining us for the first time, the Society for Humanistic Judaism represents a denomination of American Judaism that's been around for over 50 years, and it overlays a humanistic and non-theistic philosophy of life onto Jewish holiday and life cycle celebrations, education, and community. And Jews for a Secular Democracy is our pluralistic social justice initiative that addresses the separation of church and state through a unique Jewish lens. Besides these webinars that we've been doing since the global pandemic hit, we also are organizing folks on the ground, and I encourage you to get involved. You can sign up at jewsdemocracy.org. If you can't remember, JFASD.org. Either one will get you to our website where you can sign up. We're forming local groups to work on local and state issues in key states. We're obviously 3 weeks away from an election. I don't know if there's anyone who is unaware of that, but I really hope nobody is unaware of that. There's a big election coming up. But even in your wildest electoral dreams, these issues of separation of church and state will be with us because they've been with us since the idea originated. And it's been a tremendously powerful, meaningful idea in human history, and it's allowed for us as a Jewish community to flourish in America like we haven't in any other country in history, really. So it's something that we feel is extremely important. I have colleagues working on Jews for a Secular Democracy, Lincoln Dow, who you will see a little bit later, and he'll be helping us with any questions that you may have. And if you come up with questions, please write them in the chat or the Q&A box so Lincoln can see them. And our colleague Sarah Levin, who can't join us tonight, is also somebody who you should really get to know. She's been working on issues of separation of church and state for years. We are going to hear from Professor Jay Wexler in the second half of our talk, but now I'd like to introduce Professor Sherron DeHart, who is a lifelong scholar, a celebrated historian, and one of the most influential figures in the field of women's history today. Her work shines a spotlight on the pivotal role women have played in history, politics, and the legal system. Her most recent book, Ruth Bader Ginsburg, A Life, was published in 2018 and has received popular and academic acclaim. She's currently Professor of History Emerita at the University of California, Santa Barbara. And let me remove my spotlight and welcome you, Jane. Thank you for being here. I'm really looking forward to hearing from you. So this is a Jewish initiative, Jews for a Secular Democracy. And Ruth Bader Ginsburg was a Jewish icon. So let's just jump in right away with the Jewy stuff. And let me ask you, on her death, the Guardian newspaper reported that she, quote unquote, left her faith at age 17. And there was a huge uproar in the Jewish community about someone who is so identified as Jewish, and the Guardian just got it wrong. And what was it that led them to think she left her faith, and what really happened there?
Well, that's jumping ahead a little bit, but Ruth's mother, who was the predominant influence in her life, and began very early on familiarizing her with the injunctions of the Torah, introducing her to the notion of tikkun olam, by talking about Jewish women of value, of valor. And these were American Jews. She talked about Emma Lazarus and her compassion for immigrants. The same thing was true of Lillian Wall, who founded the Henry Street settlement. She talked about Henrietta Sfold, who founded Hadassah. And she also included Eleanor Roosevelt, not because she was Jewish, but because she thought she was remarkable for using her position of privilege to give voice to those who had none. And she emphasized Eleanor's compassion and her activism. So Ruth was sort of brought up on these stories of what Jewish women could accomplish. And her mother developed cancer when she was 13, a freshman in high school. And cancer at that time, and it was very serious, and cancer at that time was something one didn't talk about publicly. And she went through 4 years of high school at James Madison without telling a single friend that her mother was dying of cancer. Her mother died the day before her graduation. And the family was Orthodox. Celia, Ruth's mother's older sister, who had been born in the old country, was very rigorous in terms of adhering to ritual. And Celia and her brother, Saul, were much more interested, and I think the other sister, Bernice, were much more interested in what it meant to be good Jews and good Americans. And when Celia died, and the family began to sit Shiva, it required an all-male minyan. And Ruth was furious. And she knew there was nobody she could really complain. She thought it was an insult to her mother, who had always emphasized what women could accomplish. And she knew that there was no point in complaining. But she was really deeply alienated, and it compounded her grief immensely. So that the whole experience of sitting Shiva was not one of easing the grief, but accentuating it. And immediately after her mother's death, really within a couple of weeks, her father, who had been a retailer of inexpensive furs, along with a partnership with his brother, suffered a complete economic collapse and had a breakdown. And he lost his seat at the synagogue because he couldn't no longer pay his dues. And that was it, as far as Ruth was concerned. In terms of adhering to Jewish ritual and religious practices. In fact, she confessed to me that she never stopped working on Yom Kippur until she became a member of the court and felt she had to set a good example by not coming to the court on Yom Kippur. But she clearly identified very strongly with the basic tenets of Judaism. When she took the oath of office, she said, "I'm a judge, born, raised, and proud of being a Jew. The demand for justice runs through the entirety of Jewish tradition. I hope in the years on the bench of the Supreme Court of the U.S., I have the strength and courage to remain constant in the service to that command, and she had a framed picture of the justice thou shalt pursue above her chambers, her old chambers that I think Sotomayor now occupies. And I think that I firmly believe that the notion of repairing the world, pursuing justice with compassion and empathy, runs straight through her career, both as an advocate and most certainly as a justice.
Great. And so I want to dive in a little bit there as well. There were two things that really struck me from your book, and I thoroughly enjoyed it and appreciate it. So thank you for writing it. And I encourage folks to buy it and read it. And now I'm going to have to admit my own ignorance about certain things, which I'm a little embarrassed about what I didn't know. You know, I knew she was a remarkable person, but I couldn't quite I wasn't able to tell why she was so remarkable until I dug into your book. And I took away at least two themes. One is she overcame incredible adversity. And you just touched on one, which is her mom passing away when she's graduating high school, and her dad becoming basically no longer a father for her in a lot of ways.
Murray's father took his place in many ways and actually found him a job.
You're talking about her in-laws, her father.
Yeah.
Right. Mm-hmm. Right. So that was one adversity, but there were many others. And obviously, being a woman with career goals at that time, what shaped who she was and the work she did, and also being Jewish at that time. And so for people my age and younger, a lot of that is hard to imagine. And so can you kind of touch on some of the adversity she experienced once, like she went to Cornell, and both as a woman and as a Jewish person?
Well, at Cornell, she was actually very fortunate because she had some incredible Jewish professors in constitutional law. And she went there at the height of the McCarthy era. And she acquired a very intense appreciation of civil liberties. And indeed, it was there that she decided, on the basis of what lawyers were doing to defend those, some of those who were accused of McCarthyism, that was in line with preserving the most important values of the Constitution, and that was something that she would like to do, and applied to Harvard Law School, which had only admitted women in 1950. She applied at the end of her sophomore year to go to Harvard Law School and was accepted. She didn't go immediately because she found the love of her life, Marty Ginsburg at Cornell, and he was a year ahead of her, and the tail end of the Vietnam, tail end of the Korean War. He was drafted and sent to Oklahoma as an artillery instructor, and they had a child. So by the time when it was time to go to Harvard, the scholarship she had been awarded, Harvard wrote and said she was no longer entitled to because she was married, and that her father-in-law would have to pay her tuition. That was something that she had a very hard time swallowing. Her father-in-law, of course, was delighted to do it, and was exceedingly generous. Then she graduated. Then she went to Harvard. Marty's fourth year at Harvard, he contracted testicular cancer and very nearly died. And she, but he graduated, got a very good job as a tax attorney in New York. And when she asked the dean for permission to transfer, to take her third year at Columbia and still get her Harvard degree, he denied it. Although men had done at Harvard Law School, had done comparable things, which he had approved. So she transferred to Columbia. She was on the law review at both Harvard and Columbia, tied for first place in her graduating class at Columbia, and could not get a job because white shoe firms would not did not want to hire Jews. The few that did were very careful to keep their quota very small, and they did not want to hire women. And they particularly did not want to hire a woman with a 3-year-old child. And Ruth was very lucky in some of her professors who mentored her. Sachs at Harvard suggested that he write and suggest that she clerk for Frankfurter, because he was a Jew and he would surely understand. And he, after all, had an African-American clerk. And Frankfurter, and he even pointed out to Frankfurter that she never wore pants, which Frankfurter didn't like. And Frankfurter said, absolutely not. So then, a young professor of hers at Columbia, who was actually had been a Holocaust victim, Jerry Gunther, was in charge of placement of law students for clerks, and really made the rounds of Foley Square. Nobody wanted to hire because she was a woman and she had a child and they couldn't depend on her, etc. He finally really said to Judge Palmieri, I think she would be a perfect match. If you will give her an interview, I will arrange with the top graduate in Columbia. I will arrange with his firm to release him if Ginsburg does not work out. Well, of course, Palmieri became one of her biggest fans. And, but she really, the fact that she couldn't get a job, she felt was one of a major blow to her whole sense of herself as a professional and as a lawyer.
Right. And so that among many other inequalities that she experienced kind of fired her her professional career before she became a judge. And this is the part where I plead ignorance, and I'm so glad to now know it through reading your book, in terms of what, you know, some people have called her the Thurgood Marshall of women's rights, that she created an entire legal strategy and argued cases in front of the Supreme Court that changed the way our entire legal system understands women's equality. Can you speak a bit to her career before she became a judge?
Yes. She, when she couldn't get a job, a professor at Columbia, Hans Smith, who was in charge of international project on civil procedure, asked her to come and work as on that project as his assistant. And he was a great mentor. He thought she totally lacked confidence after this experience. And he encouraged her to give lectures in his class on civil procedure, which was her specialty, and to begin writing papers in legal journals. And after about a year or so of this, he was also involved in a project that would do projects on civil procedure in different countries. So these would be comparative. And everybody wanted to go to France. Nobody wanted to go to Sweden because Swedish was such a hard language to learn. So Hans Smith said, well, Ruth, would you consider learning Swedish and going? Which she did. And she took Jane with her child with her. Because she also wanted to see if she could make it on her own, because the 5 years weren't out from Marty's cancer. And she didn't know whether she actually would be able to manage alone if something happened to him. She went to the University of Uppsala, did a brilliant job, got an honorary degree from Uppsala for her work on Swedish civil procedure, and came back. But something also happened there. When she went to Sweden, the Swedish feminist movement was more advanced than ours. And it was an immense eye-opener for Ginsburg, both in terms of the social services that were available to support families, to support women who worked, and the debate that was ongoing in the newspaper about whether about gender roles, not only for women, but for men, and what it took for both sexes, both men and women, to parent and work and express their full human potentiality.
Right,
and if you ask her, if she was asked once at a cocktail party about her work on behalf of women's liberation, and she bristled and said, it's not just women's liberation. She was very adamant about that, and volunteered then to, when she came back from Sweden, she got a job teaching in Rutgers Law School at Newark. And at that time, the Americans, by that time in the late 60s, the American feminist movement was at a stage where a younger generation, and the Vietnam War was going on. And so there were a lot more law school openings for women. And these young women in law school wanted courses on women in the law. And they had a whole list of what they felt was discriminatory treatment as female law students. So Ruth was solicited and asked to teach a course on women in the law, which she did. And she volunteered to write the brief for what became the ACLU's first successful, and not just the ACLU's first successful, but the first successful test case on gender discrimination.
Right. And your point about her not seeing it as only for women, you know, some of the cases she then went on to do for the ACLU was actually on behalf of the men who were suffering from these discriminatory rules and laws. And I know that you also want to touch on, once she does then go from her career really changing the nature of the law toward women in America, she gets appointed a judgeship. And how does she completely switch modes from that work to becoming a judge?
Well, that was in the late 70s, and she had decided by then that she had pushed the court as far as it was prepared to go in terms of on gender equality, because the country was becoming more conservative. Reagan was elected in 1980. And in 1978, the omnibus judgeship bill passed, which was designed to increase the number of judges in the federal courts. It was done during the Carter administration, and Carter was very insistent that among these new judges, there be two underrepresented groups, women and African Americans. And Ruth really aimed for the Second Circuit. And when that didn't work out, she had also put her name in for the DC Court of Appeals. But the Carter's Attorney General just could not envision appointing as judgeship people who had done public interest law and had not been part of major law firms. So, in one sense, both many blacks and many women were handicapped by this, and Ruth certainly was. They thought as a litigator for the ACLU, she was much too liberal. And indeed, Carter, in his autobiography, talked about the fact that that there were complaints that she was much too liberal. There was an intense lobbying effort, and 4 positions on the DC Court of Appeals were filled. She still had not been appointed. Then there was a death, and she got the job, just squeaking in at the end of the Carter administration. And she was really burned by the charges, particularly from Republicans, that she was a flaming feminist and that she would be that she had no judicial temperament, etc. And so when she got on the DC court, she proceeded to do what Patricia Wald, who preceded Ruth on the DC court, told me. She said, Ruth became sanitized. She said, and Patricia Wald said, now I had done that because Carter appointed me to the Justice Department, but I was the congressional liaison. And she said, I had done public interest law before. But my years on the Hill sort of made me acceptable. Ruth didn't have that. And so when she was appointed to the DC court, she proceeded to carve what she saw as a middle way, as a moderate, and was great friends with not only with Scalia, but with Bork. And apparently there was quite a lot of eyebrow raising, to say the least, among some of the other liberals, her liberal cohort on the DC circuit, I've been told.
Right.
But when it came time for Clinton to appoint a justice, that was a plus. Mm-hmm. Because the DC circuit had become more conservative under the Reagan-Bush years. And Ruth had developed a reputation not only as a judge's judge, a very fine record, but as one who was extremely collegial and moderate.
Right.
So she got on the Supreme Court, on the Rehnquist Court, as a moderate justice.
Which is hard to even imagine it today, that was the case. And there were only 3 senators who voted against her nomination, which is also a hard thing to imagine. And I don't know whether anyone has any questions. If you do, write it into the chat or the Q&A, but just kind of to bring it full circle to the when she is a Supreme Court justice, so she comes on appearing as a moderate, and by the end, she's like the singular voice that liberals are hanging on to. So did the court move far to the right on her? Is that what happened?
Well, Linda, on the Roberts Court, in some of her dissents, Linda Greenhouse wrote a piece in the New York Times in which she said Ginsburg has found her voice, her liberal voice. Now, Ginsburg would vehemently disagree with that. She said, I was still moderate, but she said the court became so conservative that a moderate position, and that this is what Stevens found, who had been the head of the minority until he retired. And he talked about this at length. He said, I didn't change, the court did. It became so much more conservative. And that's what Ruth found, particularly. I mean, she had under the Rehnquist Court, she had Sandra Day O'Connor, who, with one exception, was a superb ally on women's issues. And even Rehnquist, who had disagreed, who had dissented in every one of her cases, except for one, and asked her when she got on the court about the Weisenfeld case that involved a young man with advanced degrees who wanted to stay home and get a what had been called a mother's pension to take care of his child because his wife had died at childbirth. And Rehnquist turned to her and he said, I just don't understand why he would want to do this. Ruth can be very persuasive. And by the time the family medical leave was up, came before the Supreme Court, I read Rehnquist's opinion. And when I went to do my interview that year, she opened the door and I said, Ruth, did you ghostwrite Rehnquist's opinion? And she burst out laughing and she said, Marty asked me the same question. Now that was just gone on the Roberts Court because particularly in relation to affirmative action, because and she really felt that after particularly after O'Connor was replaced by Alito, that there were simply too many decisions which she couldn't even from which she so firmly descended that she descended to the bench, which was a way of making known how profoundly wrong she considered the actions of the majority, of the decision of the majority. And what's interesting is that the language in her dissents changed. Under the Rehnquist court, she had always been extremely collegial, even in her dissents, never personalizing as Scalia often did. And if you read her dissents in Carhart on partial birth abortion, her dissents in Ledbetter, some of these later cases, the whole tenor has changed, which I think is what Greenhouse meant when she said Ruth has found her voice. I mean, the language is sharper. There's some zingy language, for example, in Shelby, in which she talks about Roberts, the majority's assumption that there's no longer such thing as voter suppression in these states, in these mostly southern states, and that the key section of the Voting Rights Act is no longer needed. She said, is like throwing out your umbrella in the middle of a rainstorm. And that phrase was picked up by a young law student at NYU who created the notorious RBGB blog, because she really was seen as speaking truth to power in a very straightforward way that spoke to the larger public.
Right. So we only have time for just two very quick questions from the audience. One was, I don't know if you know this, but was she questioned on her religious background in the nomination inquiry hearing, like Barrett has been questioned about her Catholicism? And if so, what did she answer? Do you happen to know if she was questioned about her gender?
I don't recall that she was. She was questioned about her feelings about capital punishment. She was very forthcoming in her defense of abortion, of reproductive rights. But I don't recall anything having to do with separation of, the whole question of separation of church and state became much more porous during the years of the Roberts courts. And in cases like Trinity Lutheran, and she was a vigorous, along with Sotomayor, was the lone and most vigorous dissenter.
Right.
I mean, she and Sotomayor were.
So this one is a little out of left field, but why not? One of the most recognizable items of RBG's dress in court was her iconic lace collar. For those of us fashion aficionados, details about that. I think I know a little bit about it. She wore different collars for different purposes.
She did. Sandra Day O'Connor started this because, you know, they didn't have neckties and they had these robes, and Sandra Day O'Connor started wearing lace fallards, and Ruth did as well. And Ruth became personalized in a way that I don't think Sandra's ever did, because she had her collar for dissent. She had different colors for different purposes. And people would make them and send them to her. So she acquired quite a large collection, and she found one that she particularly liked in South Africa.
Became this cultural icon, and so first of all, I really want to thank you for joining us. I have really enjoyed your book. I recommend it to people. It gave me a much deeper understanding of who she was, and it makes her loss that much harder now that I actually know some stuff. So I really appreciate you spending the time with us. I don't know whether you can stick around or not, but I just want to thank you, and I want to bring Jay Wexler into the conversation now. And I'm going to tell folks a little bit about him. Professor Jay Wexler has taught at Boston University School of Law since 2001. He was awarded the Michael Melton Award for Excellence in Teaching at the law school in 2009. Professor Wexler's scholarship focuses on church-state law, constitutional law, environmental law, and marijuana law. Wexler is also the author of 6 books, most recently, Our Non-Christian Nation, How Atheists, Satanists, Paganists, and Others Are Demanding Their Rightful Place in Public Life. In 2005, Professor Wexler published a study, which he put quotes around study, of humor in Supreme Court oral argument, and he tweets at SCOTUS Humor on Twitter, and I would love to find some humor in what's happening at the Supreme Court nowadays. But welcome, thank you for being here.
Thanks so much for having me. It's a real pleasure to talk about Justice Ginsburg and what's happening as we go forward. It's funny you mentioned the laughter standings. The justice would oftentimes in speeches she would mention that there was this professor who did this silly thing of keeping standings of how many laughs the different justices got, and she would often say that she was the least funny justice who talked. That was her line, because Justice Thomas, would always get 0 laughs because he never spoke. But in the last term, she got 3 laughs, which was 3 times the number of laughs as Justice Kavanaugh. So
you actually who's keeping that scorecard?
Oh, that's me. Yeah.
Okay, good.
It's a very important work, and I do it in a terribly slipshod and haphazard manner, but I do keep track. Thinking about how the court, Professor DeHart was talking about how the court has became more conservative during the Roberts era. I have a feeling we might look back at the Roberts era as a golden period for liberalism at some point. if we worry about with what's going on right now, what I thought I would talk about briefly, and then happy to of course take questions, is where it looks like we're going with Justice Ginsburg's passing and Amy Coney Barrett being nominated here 2 weeks before the election, 3 weeks before the election. And so I'll talk a little bit about that and how that might play out for church-state separation cases and areas, and then take questions if there are any. So I was trying to think, like, what difference does it make if we have a Justice Coney Barrett? And I should say, by the way, that I know Amy Coney Barrett. She clerked for Justice Scalia the same year that I clerked for Justice Ginsburg, and she clerked for Judge Silberman the same year I clerked for Judge Tatel on the D.C. Circuit. So I have some familiarity with her. But let's assume that she gets confirmed, as I think will happen, barring something even weirder than the things that have already happened. And then let's assume that the Democrats don't pack the court for whatever reason. And so it stays with a sort of 6-3 alignment. What's the difference? Because the court was pretty conservative already, right? So that's the good news, I guess, right? If you're a liberal, then the good news is how much worse could it get? Well, the bad news is it could get worse, I think. So I was thinking, when would it make a difference? One time it might make a difference is in those cases where under the court, as it had been, you had a 4-4 kind of split, and then you had the Chief Justice sort of siding with the liberals on kind of institutionalist grounds, like not wanting to overturn precedent, wanting to make the court look not like a political institution, et cetera. Cases like the DACA case from last term, or the first Affordable Care Act case, Sebelius. In those cases, it just might not matter that the Chief Justice is an institutionalist. If Justice Coney Barrett turns out not to be an institutionalist and sides more with, say, Alito than with Roberts. Now, I'm not sure that's going to happen. We don't know what Barrett will do, and I don't support the nomination because of the circumstances. But at the same time, I'm not sure she's going to be quite as say Kavanaugh maybe. I think we'll have to wait and see on that. Now, the second set of cases that might make a difference are cases where it's not Roberts who joins who would have joined with the liberals, but say Gorsuch or maybe somebody else. But Gorsuch, I think, is the one who's the biggest wild card for joining with the liberals in the McGirt case, for example, in the Bostock case. So in those situations, again, the liberals will not be saved by one quirky, switch, because there's just that much of a buffer of conservatism, on the court with Coney Barrett. So those two, and then of course it means that were something to happen to Justice Thomas, for example, or Justice Alito in a Biden administration, for example. We wouldn't turn back to a 5-4 liberal court either. So those are the three areas that I think matter. And so I think it's very hard to predict when Gorsuch will be a wild card. That's like very difficult. But one can sort of think about Roberts and the kinds of cases that he might have joined with the liberals that might not matter anymore if we go to a kind of a 6-3 court. And I was just we could talk about that in other areas of law, but since separation of church and state is one of my interests, and I think it's of interest to your to the audience, I thought I'd say a little bit about that. Church-state separation has both the free exercise clause side and the establishment clause side, where the free exercise clause is about the right of religious individuals, for example, to be exempt from general laws because of their religious beliefs. And right now, the rule is that religious believers are not generally entitled to an exception for their religious beliefs from a general law. The Supreme Court is considering whether to do something with that rule in a case called Fulton in very soon, about a month. And so this is an area where maybe you would see, where we might see a switch where the court overrules the Smith case. The Smith case is the case that was written by Scalia that said that there's no religious exemption from generally applicable laws, and might find some way, might be a much more amenable, let's say, to claims by conservative Christians to have a free exercise clause right to discriminate, for example, against gays and lesbians. So that I fear is on its way. It might have been on its way otherwise, but I think Roberts would have been less, I think Roberts would have worried about the stare decisis concerns with the Smith case, and we don't know what's going to happen now. On the Establishment Clause side, I was thinking about the different areas of Establishment Clause law. So the Establishment Clause is the part that we generally think of as the separation of church and state part of the religion clauses of the First Amendment, and it prohibits the government from advancing or promoting religion in certain ways. And it used to be very, very important. Now it's not so important really, because it's been 15 years since the Supreme Court has struck down anything under the Establishment Clause. That was a case striking down a type of Ten Commandments monument or display in a courthouse in Kentucky. But if you think about those areas of law under the Establishment Clause, one of the areas of law has to do with putting up monuments and displays on government property. I think that is something that is that the liberals have lost out on. I think that's something that the conservatives have changed the law about. They upheld a 40-foot cross on public property on the theory that a cross is not a religious symbol. So I don't know how much worse that could get. And then there are other things like we call them ceremonial deism, like in God we trust, on the money, the Ten Commandments and the courthouse freeze, etc. That wasn't going anywhere either. So I don't think there'll be a change there. Government money going to religion, that's something that has changed a lot in recent years, and basically the Supreme Court has said, as long as you do it in a formalistically appropriate way, send all your money to religion, that's fine. Used to be much, much harder for the government to fund religion. So I don't think that's certainly not gonna change, but the liberals have lost that also. If there was any doubt about it, the Espinoza case from last term, I think, made that clear. But the two things I was thinking about, though, that really might be in play are school prayer and even perhaps teaching of like creationism. Those are two areas of law in which the Supreme Court is still, the cases are older, but they're still pretty solidly on the ground on the side of separation. But I'm not sure. Justice Scalia would have come out wrote the dissent, a scathing dissent in the graduation prayer case, Lee versus Weissman, a fascinating case from Rhode Island. And I don't know if Coney Barrett, I don't know what she thinks about that kind of issue, but I could see that being in play. Like if I was a conservative, I would start teeing up the school prayer cases. I don't think I'm giving anybody any ideas by mentioning that. I'm sure it's in the works. And maybe, I don't know if people care as much about creationism or evolution and its alternatives as they used to, but those cases are also, I can imagine a Supreme Court that was not so wary of church and state getting together, looking at those kinds of cases and saying something like, hey, look, if you don't, believe in creationism or whatever, you can step out. Your parents can let you, or you don't want to do a prayer in class, get your parents to sign you out and you don't have to partake in it. Now, the cases that exist now say that doesn't matter. But that's where I worry, because those are the pieces of the Establishment Clause that are still left. And I hope they remain there, but I think there is at least some risk that we would see the court going backwards, in my view anyways, on those issues. So I'll stop there and just and see if anybody has questions, or Paul.
Sure. Well, yeah, you dumped so much and I have so many questions about it. And folks, if you have questions, put them in the chat or the Q&A. So help me understand. So there are two areas that you may have touched on, but that I'd like to drill down on further, that are really my biggest concern is about reproductive rights and women's rights. And I think that's the biggest concern for a lot of people, but yet it seems that the tactic happening right now is to focus in on healthcare and Obamacare, which I presume there's a political reason for that. They don't want to alienate anti-abortionists, I guess. But those are the two things I'm wondering about as well.
Right. So I don't, the ACA case that's coming up before the court, I just have not looked at closely enough to to know what to say about it. I apologize for that. It's just, there's so many things happening. So yeah, that's on my list of things to to look into. But
Well,
I don't know.
your overall message is that we're so deep in the hole anyway that this is not that big a deal because we're already so deep in the hole on some of these issues.
Yeah, except that that Roberts, seems to want to, has at least some reluctance to overrule the ACA, and that just might not matter depending on what she thinks of the issues of the case. Twitter was really complicated on that stuff. I thought maybe I could figure it out watching Twitter, but that was a ridiculous idea, how you could figure anything out on Twitter. Although I can't stop watching it anyway either, so I don't know what I'm... Now, on Roe versus Wade, I think I would be surprised if we saw a case that just said we're reversing Casey, we're reversing Roe, straight out. But I would not at all be surprised if we saw little dents coming through, and perhaps so many dents that it becomes that the right to choose becomes an empty right, at least in some places. So that would be my thought. I doubt that they'll go 180 on it, but I think absolutely. I don't think Kavanaugh, Gorsuch, and Coney Barrett were chosen, without some pretty good confidence about what their views are on those questions, and so I think that's definitely in danger.
Yeah, and it's been interesting actually to learn about Ruth Bader Ginsburg, and her approach to Roe v. Wade was one that was critical. I mean, she didn't litigate that case, but she felt that they went about it in the decision was so sweeping that they missed an opportunity there, and there's some controversy about whether she's right or not, and we'll never know, of course, but it seems like the alternative is happening, which is we're just going to keep chipping away at that broad sweeping decision.
Yeah, that's probably right. I mean, I think if I'm correct, and Professor DeHart could correct me if I'm not right about this, but I think Justice Ginsburg was thought that the political process was going in the right direction on the abortion situation, and that the big sort of the sweeping kind of decision of Roe versus Wade, put a halt to any of that and made the issue that much more divisive. And as you say, who knows what would have happened without it. But she was a minimalist and an incrementalist, and liked to take things one step at a time, and was not into these big sweeping kinds of pronouncements. So that makes that's, at least from my understanding, very consistent with everything she saw in herself as a judge and a justice. So,
and you did touch on LGBTQ equality, and for us, for our initiative, Jews for a Secular Democracy, that's another big pillar that we're very concerned about. And again, there was a major decision within the last few years about legalizing gay marriage, and it seems like that's something that might also be attempted to be chipped away at, or once it's there, they're not gonna remove it.
Yeah, I mean, I would be very surprised if the court were to, even this court were to reverse Obergefell and say that and put it back to the states to decide whether gays and lesbians can marry. On the other hand, I think the big battle will be about religious conservatives and whether they have an exemption from general anti-discrimination laws, basically a license to discriminate, like in the Masterpiece Cake Shop case and in cases like that. And that could, that, I think that's where the battle is going to be, at least at first. And with the court looking the way it is now, I think we're going to see the court carve out those exceptions one way or the other. And not clear exactly what doctrinal hook they'll use, but it won't probably matter that much. And so I think that's definitely a fear.
And how can that be mitigated by legislation if there becomes, I mean, we could be looking at decades worth of a conservative Supreme Court, and if we then somehow have a much more liberal House and Senate and president. Can you override that through laws?
Well, so I guess I just said it doesn't matter what doctrinal hook they use to get those exceptions, but I guess it does in a sense that if the conservatives on the court find that there's a constitutional right to discriminate, to have for sincere religious believers to have a right to an exemption from generally applicable laws that they believe substantially burden their religious beliefs and practices. If it's constitutional, then there's nothing a liberal Congress could do. If instead the rationale rests on something else, an interpretation of a discrimination law, for example, that might be different. In which case, the liberal political branches could go back and write those laws again. But there is always the constitutional possibility, and we'll have to watch the Fulton case that's coming up, which is the case about from Philadelphia about Catholics. I forget the exact details, and I hate making things up, so I won't. But that's going to be a pretty intense case, and I think it's going to give us, especially if Coney Barrett is on the bench by then, it'll give us a sense for what's to come. Great.
And I find it. There was a case in an adoption agency in South Carolina. I don't think it may be the Madonna. Is it Madonna? I forget the name of the case, where basically they said not only no gays, but no Jews, no Catholics, and they receive federal money for their adoption. It's an adoption agency. It's only one kind of Protestant that they will adopt kids out to. A woman who I believe is Catholic went through the whole process. Everything seemed great, and then they're like, "Oh wait, you're Catholic. No, we're not gonna give you this child." And it turns out it's not just Catholic, it's Jewish, it's gay, and they get federal funds. And I don't think that's been decided yet.
Huh. Well, I mean, with all the Catholics on the court, will that affect the analysis at all? Interesting.
Yeah.
This whole question of exemptions from general laws is a really fascinating one, because it's been going on for a century at least. But when this case I was talking about, the Smith case, was decided, the one that said basically no religious exemptions for general laws, that was a very unpopular opinion. Everyone hated the opinion at the time. From the ACLU to the Christian Coalition came together and wrote a statute to try to undo it. Because at the time, the people who were bringing those religious exemption claims were minorities, right, who were trying to get exemptions from laws that were passed by large majorities that happened to burden whether it's a prohibition of peyote, or you can't wear a head covering in the army, the Golin versus Weinberger case. But with the shift, the really quick social shift in gay marriage and recognition of same-sex couples, and it's the whole valence, is that the right word? I don't know. It sounds like too academic of a word, but the whole conversation over this issue is completely different now. Now it's not like, can a Native American have an exemption from a general law about peyote, but now it's, can a million really conservative Christians discriminate against 10% of the population based on their sexual orientation? And the way that's changed as a social phenomenon and makes us think differently about the legal question is that's a really interesting area.
And that is the Religious Freedom Restoration Act that you're talking about, right? That was kind of initially had overwhelming bipartisan support to allow for the kind of exemption you're describing, where a Native American wants to use peyote, but you don't want to let everybody in the country use it just because it's fun. I mean, you want, it was for religious purposes. And it morphed, it got taken over. And now it's being used like in Masterpiece Cake, where they're not going to sell to gay men for their wedding cakes and so on. And it's all these little points of discrimination, which I think as someone who's Jewish, I feel very attuned to, because and as with I mentioned this South Carolina adoption where they included Jews. In most of these cases now, it's not Jews who are on the front lines of this discrimination, but we should know from our history that we're not that far.
We're not that far back.
From that front line, and therefore we have to be upfront about pointing it out. And I do know that there is a legislation working its way through called the Do No Harm Act, which is trying to counteract the way that the RFRA has been interpreted. But again, if I hear what you're saying, if they say it doesn't matter, this is about what the Constitution says, then you're saying even if that Do No Harm Act gets adopted somehow, I mean, the Senate would have to flip, but even if that happens and they pass this legislation, that the Supreme Court can still say, no, it's a constitutional right that you can decide who to sell who to sell to. Yep. And you can't do it by race, though, because that's a done deal. Like, they can't then say, we're not going to sell to gays and we're not going to sell to African Americans.
That's right. And Masterpiece Cake Shop, the federal government had a paragraph in there. I think I'm right about this. A paragraph saying we're not saying anything about race. Race is still, you can't discriminate on the basis of race. But how do you, like, that right. really does not persuade, I think, right? So I don't know. I don't know.
Well, thanks. I mean, I think it was unfair for me to expect you to come and make me feel better about what's happening.
Oh, was I supposed to do that? Yeah. Sorry.
You kind of did a little bit. I mean, you certainly put it into perspective a bit about what's realistic, what might happen, what are the scenarios, and so on. One thing you did mention that I wanted to kind of also ask about is court packing, which seems to me like, and that's the idea, of course, that Congress could add more Supreme Court seats, but it seems to me so far-fetched. I mean, FDR couldn't even do it. You would need the Senate to flip, and then you'd need these new Democratic senators to vote for it, who like just got elected in a purple state. You know, how science fiction is that?
Well, that's a political question, and so I have very, I trust my political judgment almost not at all. But it does seem like, so Biden's avoiding it, right? And no Democrats are talking about it, right? I mean, some Democrats are, of course, but the people are they know it doesn't poll well, right? And so they're not talking about it now. Whether everyone's got a plan that they're hatching, and that's what Ted Cruz thinks, right? He thinks that all the Democratic senators are just ready to jump on day one on the Ruth Bader Ginsburg expand the court act of 2020. I really have no idea. And I also don't even know what I think about it generally. Like I really wished it was not going to come to, I wish it had not come, obviously, to where we are now in so many ways.
One final question I have, and let me ask the question and see if I could frame it from the Q&A, because the question seems to be basically about the internet and about free speech and hate speech and electronic communications, and is there a concern that the court is unable to address it because things move so quickly? And Peter, you can chat whether I'm getting your question right or not. Are you aware of stuff that's going on about the internet in the Supreme Court and freedom of speech?
Internet, I mean, not in the first. I mean, there are First Amendment internet questions like, is the president's Twitter feed a public forum? So could he exclude people? And then there's a whole big conversation about hate speech and whether there should be laws against hate speech. I think I doubt we're going to see the court. I don't think we would have seen the court anyways go down that road of allowing the government to punish hate speech. There are certainly strong arguments in favor of prohibiting some kinds of hate speech, and European countries do it, but it's very contrary to our tradition. So I would be very surprised if we saw the court go that way, I think. But as to the intersection between the hate speech and the internet, I'm not really sure.
Mm-hmm. And so my last question is just to kind of give you the forum around the book you wrote recently and this idea of the rising number of secular Americans, for lack of a catch-all phrase for them. Obviously, we are the Society for Humanistic Judaism, and we consider ourselves humanists. When we create a pluralistic Jewish initiative like Jews for a Secular Democracy, for us, pluralism in the Jewish community requires us to include secular Jews as well, which is not always the case in the Jewish community. When they talk about pluralism, they mean like from Reform to Orthodox. So talk a little bit about what the rise of secular Americans, what has it been, what's happening with that? Does that provide a glimmer of hope for us on these issues?
Well, it does to me. I mean, I'm an atheist, and of course we've seen the numbers in all these Pew data. We see the number of people who identify as Christians getting lower, and we see the number of people who identify with minority religions and nuns growing. And what my book is about is basically we've already made it to pretty much a post-separation of church and state place, where we're not where those of us who think that there should be a significant separation between church and state have lost most of our battles. And so what do we do? The book is about what do we do in that situation? And the argument is the only thing that's left to do really is to participate in public life alongside Christians and make ourselves known and put up our own monuments and give our own invocations before government bodies and ask for our money ourselves and, start secular groups in high school and all those things. It's really like it's kind of a second best or third best, maybe, I don't know, solution, but it's like it's the only one that strikes me as left, and even worse, even harder to keep fighting in the courts, now, if the court does indeed go to this kind of 6-3 place. So,
well, I do find that optimistic, and so we'll end it on that optimistic note. But as a humanistic Jew, as a humanist, as a Jew, this is why I'm doing what I'm doing, because I want to be in that public space. If we have to be in public space with our beliefs, then I want to make sure we're heard as well. And so I think that's an appropriate thing, particularly in looking back at Ruth Bader Ginsburg's legacy, because that's certainly something that she did, and she brought her Jewish identity with her to do what she did and to make the world a better place for us, and hopefully we can carry out that legacy as well. So thank you so much, both Professor Wexler and Professor DeHart, for being here tonight. I really appreciate it. And thank you all of the participants, and we'll continue with this series, and we hope to see you soon.
Great. Thank you so much. Have a good night, everyone.
Take care. Bye-bye.
Bye.